because you alone are God. You alone are worthy to be praised. We want to thank you for saving us. We want to thank you for the blood you shed for us. We want to thank you for redeeming our souls from death. We want to thank you, Lord, for your mercies, your abundant mercies. Lord, thank you for your goodness and for your kindness. Thank you for watching over us day and night. We want to thank you for the abundance of all things. The things, beautiful things you have blessed us with. We want to thank you for the health, good health we are enjoying. Lord, thank you. Father, we thank you. We bless you. We exalt you. Lord, you are the judge of the whole earth. From you proceed all laws, judgments, all good laws come from you. Your law is perfect. It is your law alone that converts the human soul. We want to ask you to come and take your place as the discussions go on, as the lecture comes up. We want to commit everybody here into your hands, the guest lecturer, all the that are seated here, the judges, the lawyers, every soul that is here gathered. We are asking that your spirit will be upon us. And at the end of the day, your name shall be glorified. At the end of the day, your law, according to your word, that your law shall go forth out of Zion, and the word of the Lord from Jerusalem. We are asking that you will help us. Pour out your grace and your spirit and your power upon us. And bless us for coming to this occasion in the mighty name of Jesus. Thank you for safety granted all from far and near. Lord, we bless you. In Jesus' name we pray. Amen.
Amen. Please, can we kindly remain standing for the national anthem?
Nigeria, we hail thee, our own inherited land. Though tribe and tongue may differ, in brotherhood we stand. Nigerians old and proud to serve our sovereign fatherland.
Okay, thank you. You may be seated. That was the first one. That was a very short one. Once again, it's my pleasure to welcome you all to the 5th annual lecture of Akaraiwe and Associates, Lex Rehoboth Partners. You are all welcome to this great event. You all know that this is the annual lecture that started in 2021 and has been very impactful from the beginning. And the theme of today's own is the role of legal profession and justice delivery in Nigeria. But before we go into the main lecture, I want to recognize the presence of the dignitaries, the distinguished persons around. I welcome to this great occasion the chief host, which is the governor of Enugu State, and the chief judge of Enugu State, in the person of Honorable Justice Oze Emena. We also welcome the presence of the guest speaker, whom you all know, and the person of Honorable Justice Emmanuel Akomoye Agim JSC. My Lord, you are welcome. We also welcome the presence of the chairman of this occasion, our able president of the Customary Court of Appeal, Enugu State, Honorable Justice G.C. Nnaman. My Lord, you are welcome. We also welcome and recognize the presence of the justice of the judges of Enugu State High Court. My Lord Justice Oledo is here. My Lord Justice Ugwabo. My Lord Ian Namani is here. You are all welcome. Oh, my Lord Justice Ngobudo. My Lord, you are welcome. So sorry I didn't see you. You're all welcome. Then the magistrates, our worship, that are here with us, the chairman of the magistrates of Nigeria. You're welcome, sir. And all that's CKC Udu. Your worship, you're welcome, and all your worship here present. We also recognize the presence of Leonard Silk here present. I'm so sorry. Chief Iom Edith Ofia SAN. I hope I'm correct. I'm not correct. Okay. I'm so sorry, I'm so sorry. Iom Edith Ofia. You're welcome, my Lord. Leonard Silk, you're welcome. Then we welcome the presence of Anthony Annie SAN. Leonard Silk, you're welcome. Then we recognize also the presence of Johnny Agim, all the way from Calabar. You're welcome. Then we welcome our very own person, the presence of Ikechukwu Onoma SAN. You're welcome. I don't know if it's Mbaduya SAN I'm seeing there. I welcome you, sir. Thank you for honoring this lecture. I also welcome the presence of Gozie Obi SAN from Anambra. He's one of the discussants. Sir, you're very much welcome. And all the elders of the bar here present, please, as I get their names, I will recognize them in the course of the lecture. You are all welcome. All the distinguished guests, you are all welcome. Students here present, you're welcome. The representative of the Dean, Faculty of Law, University of Nigeria, Nsukka, University of Nigeria, Nsukka, in the person of Professor Enugu Campus, Professor Festus O. Ugweze, ably represented by Dr. Collins Ajibo. You are welcome. It's an honor to have you here present in our midst. We don't take it for granted. You're ably welcome. I also want to welcome and recognize the presence of Chief Emeka Obegolu, SAN. Please write it. Chief Augustine Alege, Senior Advocate. Is he here? Yes. So sorry for the mistake. May I humbly welcome and recognize the presence of Chief Augustine Alege, SAN. You're welcome, sir. Chief, you're welcome, sir. The former NBA president. Our family is here. Oh, we are really being graced in this occasion. May I recognize and welcome our Institute Bar President and the presence of Mazi Afam Osigwe SAN, our Institute President. You're welcome, sir. Thank you so much for honoring the invite. Thank you so much.
Senior Advocate of Nigeria, Chairman GCPC.
We also have in our presence Abdul Mohammed SAN, the Chairman AGPC 2026. Sir, you're welcome to Enugu State. And for the second time, you're welcome, sir. We also welcome the alternate chair, AGPC to 2026, Sami Somiari SAN. You're welcome, you're welcome to Enugu for the second time. Thank you. We also welcome the presence of Musa Ada SAN. You're welcome, sir, to Enugu. We also welcome Alta Oyada, the current Welfare Secretary of MBA. Sir, you're welcome. Thank you. We recognize you. Thank you so much. Okay. Also in our midst is Barbara Amosu. Am I correct? Barbara Amosu, the Secretary AGPC 2026. Barbara, you're welcome to Enugu. Thank you so much for gracing this occasion. He's a hopeful. What is he contesting? Okay, also here in our midst is Mr. Afam, Chief Afam Okeke, pardon me, former Chairman Abuja Bar. You're welcome, sir. You're welcome. Thank you so much. Another person.
Welcoming the chairman this time, as in
The chairman of
introduction of the chief first, which is not here with the chairman and other members.
That's what we have done now. So we want to vote.
Yes, to take on.
At this juncture, may I welcome the chairman of the occasion, in the person of the Honorable Justice G.C. Namani, PCCA, President, Customary Court of Appeal, Enugu State. My Lord Justice, you're welcome. Sir, I am welcoming you for your welcome address. May I invite him to read his welcome address. The chairman, Honorable Justice G.C. Namani, for your welcome address, sir.
Before he delivers this, let the Supreme Court Justice, yes,
Okay,
call him up and they discuss that.
Okay, so
Good morning, my brothers and sisters. It is good to be here today. I want to thank God for Ikazo Akaraiwe SAN. He has emerged and sustained his position as the undisputed heavyweight champion of continuing legal education in the Southeast. Please, a round of applause for him. We pray that God Almighty will continue manuring and fertilizing his mind, his brain, and also to deepen his pockets with economic empowerment to sustain this from year to year. This year's edition is spectacular, not just because of the choice of topic, but because we have here the eagle on the Iroko, Honorable Justice Agim JSC. I can swear that some of us in this hall have seen him only on pages of newspaper, magazines, the television, and through the law reports. If you have read his judgments, and I believe you have, every of his judgment is a cornucopia of erudition, of literary finesse, of the burning desire for justice, of bravery, sometimes daredevilry. Today we have him in flesh and blood. The Igbo man has a proverb. He says that if you climb the Iroku tree, get as much firewood as you can, because it is a feat you don't accomplish twice in a lifetime. So we're going to harvest you, my Lord, today with a giant basket. I'm going to make this very brief because we're starting ahead of, behind schedule. But just put this way, the Englishman, in his list of menu, even the French, they have what they call the pudding. The pudding is like a dessert, sweet cake with sugar and all that. So they say the taste of the pudding is in the eating. And Igbo man also says that the parcel in Nsuka area, we call it ngugu. Ngugu is a parcel wrapped meat, which you are going to unwrap and eat freely from. You don't need to burrow hole into it and steal from it. So I'm not going to go into anything. We just go and take my seat. But I only warn you, we're going to fly at high altitude and supersonic speed. So fasten your seatbelts. Thank you, ladies and gentlemen.
Thank you so much, the chairman. And right now we're going to introduction of the members of the panel and the guest lecturer. May we welcome to the podium the guest lecturer for today, Satusi, Honorable Justice Emmanuel Akomaye again. Sir, you can join him. Honorable Justice Chinelo, lead him to his seat. Then members of the, sir, you're welcome. My Lord, you're welcome. Then the discussants are Anthony Ani, SAN. Leonard Sick. We have Gozie Obi, SAN. Please, can you lead them to their seats? We also have Johnny Agim, SAN. Mr. Agim, you're welcome. We have the chairman of the chairman of Enugu State. That is in person of VC Odo. You're welcome, sir. You're welcome. Have your seat here. Then Mrs. Joy Nani is one of the discussants. Please, you're welcome. While the chairman of the occasion was giving his welcome speech, some dignitaries walked in. We have the person of Caroline Etuk, Mrs. Caroline Etuk, Director of Multi-Door Court. You're welcome. And also, my Lord, Honorable Justice Aluku, you're welcome, ma. Thank you for coming. Then may I welcome Chief Mr. Rapulondoka for the citation of my Lord, the guest speaker. Rapulondoka, are you here? Chinelo. So sorry. Mr. Rapulondoka, are you here? In the absence of you can know it's better you do it. In the absence of Mr. Rapulondoka, Mr. Ikazo Akaraiwe SAN will take the citation of my Lord.
My Lord, the chairman, my Lord, the guest lecturer, my lords, the president of the Nigerian Bar Association and his entourage, distinguished senior advocates of Nigeria, my learned friends. Our guest lecturer, Honorable Justice Emmanuel Akomaye Agim, Justice of the Supreme Court, Commander of the Federal Republic, Order of the Republic of the Gambia, is a man of so many parts. He was once a justice of the Court of Appeal here in Nigeria, a justice of the Supreme Court of the Kingdom of Swaziland and the southern tip of Africa. He was also the Chief Justice of the Gambia, which is the first time I heard of him when I went to the Gambia for the African Commission on Human and People's Rights. He is also, as we speak, member of the ECOWAS Council of Chief Justices. He was once member of the ECOWAS Council of Chief Justices, I beg your pardon. He was also member of the committee in charge of preparing the processes for the formation of the West African Judges Forum. He was also one time Justice of the Supreme Court of the Gambia, as well as President of the Court of Appeal of the Gambia. Before he became the President of the Court of Appeal of the Gambia, he was Justice of the Court of Appeal of the Gambia. He was also Chairman General Legal Council of the Gambia, Chairman of the Capacity Building for the Judiciary of the Gambia, Director Judicial Training in the Gambia, Chairman of the Gambia National Law Reporting Council. He was also the DPP in the Republic of the Gambia, as well as lecturer in the University of the Gambia and lecturer in the Gambia Law School. Without attempting to be unduly contentious, my Lord is one of the most experienced justices in Nigeria today. And my Lord, the chairman was not flattering when he says that an excursion into his judgments is an excursion into high intellectualism. His qualifications: LLB Hans University of Calabar, BL in the Law School Lagos, and LLM International Trade Law from University of Wolverhampton in the UK. He has been honored several times, including but not limited to CFR, Commander of the Federal Republic of Nigeria, ORG, Order of the Republic of the Gambia, and appointed a professor of law in the West African Insurance Institute, owned by the 5 English-speaking West African nations. He has his LLD honoris causa, University of Calabar, Nigeria. His publications include the Gambia Legal System, which is today the authoritative text for Gambia University and Gambia Law School. He has also written a book, The Pre-Trial Criminal Processes in the Commonwealth States, The Gambia Experience. He has also written the Commonwealth Guidelines for Treatment of crime victims. He is the co-author of that book, and there are many unpublished works. His contributions to development of law and society include, but are not limited to, restatement of the law on the proper application of Section 17 of the Advanced Fee Fraud Act to enable a lawful, fair, and transparent process of non-conviction forfeiture of property. Melrose against the EFCC. He has expanded the frontier of the scope of the law on duty of care in case of negligence by electricity providers. The case of NEPA and Awalu. Number 3, he has stated the scope of the right to privacy to include right to vote in private. The famous case of Onwali and EBSIEC, Ebonyi State Independent Electoral Commission. Number 4, he laid the pathway on the interpretation and application of the 2022 Electoral Act to give effect to the innovations therein so as to provide for free and transparent elections. Oyetola and Adeleke. He laid the pathway concerning how to lawfully change national currency in the famous case of Attorney General of Kaduna and Attorney General of the Federation, 2023. Number 6, stopped the decades-old frustration of local governments by state governments. See the case of Attorney General Federation and Attorney General Abia and others. And stopped the decades-old number 7, set the legal limits for the police patrol to prevent crime. See Eyin Naya against the state. Number 8, stated the undesirability of payment of severance and pension benefits to holders of public office in one of the Supreme Court judgments. Number 9, stated the illegality of the Governors Forum and the Algon exercising states and powers of the local government area. See Ryok's case. Number 10, declared sovereignty of Nigeria as belonging to the people of Nigeria. Attorney General of Kaduna and others, and Attorney General of the Federation and others. His work experience in a nutshell includes private legal practice after his call to the bar, and then DPP work as a public prosecutor in the Ministry of Justice, judicial work, judicial administration, judicial training, a law teacher, a writer, a law reporter, an expert in legal systems. My lords, distinguished ladies and gentlemen, join me as we welcome our very distinguished guest lecturer, Honorable Justice Dr. Emmanuel Akomaye again, to the podium to deliver his speech. If I'm not asking for too much, we may even stand up to give him that honor. Thank you very much. Thank you very much. My Lord, you're welcome to the podium. We have been waiting for you, and we are ready to drink from your fountain of jurisprudential wisdom. Thank you, my Lord. You're welcome, sir. Please be seated.
Gentlemen, sit down. I'm humbled by the citation. Sometimes you do not remember that you did some of these things until they mention them. We thank God for everything. Who made that possible? His will must prevail in everything, not our will. The chairman of this occasion, my Lord Justice Nnamani, the president of the Enugu State Customary Court of Appeal, judges of the High Court here present, the President of the Nigerian Bar Association, Mazi Afam Osigwe, he still has, there are tested generals in the field. Mr. Ike, I did not recognize Adagara. Is it Adagara? They strong lawyer. Okay. So I saw her today, I was surprised. I thank Mr. Akaraiwe for inviting me, and I accepted because of my friends here. And Mrs. Sophia, Ike Onoma, her son, and a whole lot of them. Mr. Ani is here. Enugu is a place I always look for an excuse to visit. So when one came, I didn't miss it. I thank God Almighty for journey mercies for all of you. I have come to engage in discussion again. Sometimes I used to wonder whether it is worth it, because we have been talking for years. I don't know whether things are improving, but we'll keep talking. We will not give up. So much has happened in recent times that make further discussion of the role of the courts and legal practitioners in the functioning of the Nigerian legal system necessary. The now common tendency of legal practitioners to lead or instigate the public blame of the courts alone for any real or perceived problem in administration of law and justice and the functioning of the legal system suggests that they do not regard their duty or role to support or work with the courts to administer law and justice to ensure an optimally functioning legal system. The courts and legal practitioners have joint responsibility for administration of law and the functioning of the legal system. This discussion is to remind us of this joint responsibility. Generally, frequent discussions of the role of the courts and lawyers in the functioning of the legal system is an engagement that helps the improved functioning of the legal system. Such frequent discussions make the courts and lawyers to remain conscious of the role imposed on them by law in the functioning of the legal system and enable them measure their role performance so far and the impact on the well-being of the society. Since the society is dynamic and its legal system should evolve with it to be relevant, useful, and effective, such continuous examination enables the courts and lawyers assess if their role performance is helping the legal system evolve to meet the demands of changed circumstances. Such frequent open discussions also help the public better understand how the courts and lawyers operate to contribute to effective and efficient application of law and justice delivery, and enable society know the relevant parameters to objectively evaluate the role performance of lawyers and the courts, and thereby promote public confidence in the legal system. Do we really understand that as judicial officers and legal practitioners, we are the midwives of our legal system and the custodians of the rule of law? That we are primarily responsible for driving the legal system and ensuring the complete rule of law. That we do this primarily by our advices, actions, presentations, submissions, decisions, in each case in the courts or any dispute resolution process. That each case is not just about resolving a dispute between parties, and is more importantly about meeting the requirements of an objective of law and the objective or interests of the society. That therefore at all times in each case we must carefully consider and measure if each of our advices, actions, presentations, submissions, decisions meet these requirements and objectives, and strengthen or weaken the working of the legal system. And do we really understand the nature and structure of our legal system? I'm minded to raise these questions from my experience of the practices of lawyers and the courts in the past 40 years. And again, from what is happening today. Everybody says the court. Everybody is blaming the court for this and that and that. And the lawyers are at the forefront. Then I ask, do they really know that the courts, they have a role to play? It's not just the courts. Because if they do, some of those blames will go to them. The legal system of a state consists of the laws, the institutions that make and administer the laws, and the methods of administration of the laws. In Nigeria, the laws consist of the Constitution of the Federal Republic of Nigeria, acts of the National Assembly, laws of states, customary laws, and Islamic law. The laws reflect the fundamental values of the society, an expression of the yearnings and aspirations of the people, and constitute an edifice of principles, values, and statements which a society is committed to. Its objective is to provide an answer to fundamental human needs. Helen Ann Kennedy, QC, Baroness Kennedy of the Shore, member of the House of Lords of the United Kingdom, director of the International Bar Association Human Rights Institute, and the law reform think tank said, law is the bedrock of a nation. It tells who we are, what we value. Almost nothing else has more impact on our lives. The law is entangled with everyday existence, regulating our social relations and business dealings, controlling conduct which could threaten our safety and security, establishing the rules by which we live. It is the baseline. Law is created by God to enable man enjoy his status as God's best creature. Law preserves order, peace, and security of lives and property, makes the society secure and stable, regulates relationships, regulates and shapes the behavior of citizens, safeguards expectations, functions as a means of governance, a device for the distribution of resources and burdens, a mechanism for conflict resolution, and a shield or refuge from misery, oppression, and injustice. Through the discharge of these functions, the law has today assumed a dynamic role in the transformation and development of societies. It has therefore become an instrument of social, political, and economic change. Governments rely on the use of law for promoting development. Whatever plans of change of development are contemplated, these have to be introduced through legislation. We live under the rule of law. But the law cannot rule or perform these functions unless it is made, administered, or enforced by institutions established to make, administer, and enforce it. These institutions are primarily the legislature that makes the laws, the judicature, the courts that declare the law and determine the lawfulness of all actions, the executive that execute the laws, legal practitioners that have the exclusive responsibility to act as legal advisors, to represent persons who seek justice through law, and to guide the courts in the application of specific laws to resolve disputes. Other institutions of administration of law include quasi-official bodies like professional practice regulatory bodies that statutes have given exclusive responsibility to regulate practice and service standards in certain spheres of human life, such as healthcare, engineering, architecture, banking, etc. The role of the courts and legal practitioners in the administration of law is a more fundamental and central determinant of the effectiveness of law in realizing its objectives and in performing its important role to society and the functioning of the rule of law. As earlier stated, the courts declare the law and determine the lawfulness of all actions, including legislative and executive actions. And the legal practitioners have the exclusive responsibility to act as legal advisors and represent persons who seek justice, and to guide the courts in the application of law. Most of the judicial officers that constitute and manage the courts in Nigeria are basically legal practitioners on the bench. There are very few judicial officers in some customary courts, Kadi courts, and area courts that are not legal practitioners. Legal practitioners, particularly private legal practitioners, law offices, corporate, academic, in-house legal practitioners in corporate bodies and other organizations, etc., that are not on the bench are at the bar. The bench and the bar collectively constitute the legal profession. The law being the centerpiece of the legal system of a state, the strength of the legal system will depend on how effective the rule of law is. The less effective less effective law is, the weaker the legal system. Contemporary experience has shown that a weak or collapsed legal system can result in the failure of the entire state structure. A strong and optimally functioning legal system is therefore absolutely necessary for the existence of good governance and a viable state structure. Since the role of the legal profession in the administration of law is a more fundamental and central determinant of the effectiveness of law in realizing its objectives and in performing its important role to society and the functioning of the rule of law, the effectiveness of law depends on how the courts and lawyers perform their roles in the administration of law. Therefore, it follows that the strength or weakness of the legal system and the effect on the well-being of society as a whole depends on how the courts and legal practitioners discharge their roles in the administration of law. It is primarily through their role in the functioning of the courts and other established dispute resolution processes in the effective and efficient application of law and administration of justice that the role performance is measured. The public perception is that the courts and other established dispute resolution processes are not functioning properly in the effective and efficient application of law and justice delivery. The generally expressed concerns are about delayed trial processes, an attendant lack of hearing within reasonable time, very stressful and frustrating access to courts and justice, corruption, lack of independence, conflicting decisions of courts, particularly Supreme Court, and uncertainty of binding precedents. abuse of court process by multiplicity of suits over the same event that often results in contradicting orders of courts of coordinate jurisdiction with attendant institutional embarrassment and allegations of corruption. Unethical practices and professional misconduct by legal practitioners, poor knowledge of law, incompetence of legal practitioners and judicial officers, frivolous litigations, a very weak regime of alternative and consensual dispute resolution, misuse of judicial power or authority, pervasive acute indifference to the demands of substantial justice in each case, abuse of legal and court processes generally, poor public perception of the courts, etc. There is no doubt that some of these concerns are real, while some are imagined. These weaknesses, whether real or merely perceived or imagined, suggest some failure in the role performance of the courts and the legal practitioners that are jointly involved in the justice delivery processes. There is, however, a growing inclination to blame the courts as exclusively responsible for these weaknesses. But the current experience is that legal practitioners appear to be largely responsible for this blame. The mobilization of more public opinion against the courts in the electronic, print, and social media, international and local conferences for any real or imagined weakness in any process or proceedings, in many cases, particularly political cases, is now common. The resulting situation is that the public is misinformed on the reality of the situation and is deprived a proper understanding of same. The huge loss of public confidence in the strength and ability of the courts to effectively and efficiently apply the law and administer justice is largely caused by this situation. I have deliberately avoided listing some known incidents. Let me just mention one of them orally. A lawyer from Abia State attended the International Bar Association conference in some 3 years back and went there and condemned the courts in Nigeria in very, very bad terms. Some lawyers from Nigeria who were there were not happy with him and made him understand that they were not happy with him. I said, well, I really pitied him because some of us have had the privilege of working in other countries, and we know that our courts represent about the best in sub-Saharan Africa. There's no doubt we have our problems here. Because you are not there, you glorify them. If you are there, you will understand. We've been in several fora, and we know how the Nigerian judges are perceived. But that is no justification for any shortcoming anywhere. We do not want any shortcoming or any weakness to exist anywhere. So it's not an accolade, a general accolade for everybody. It's for those who are doing their job very well, please. The reality, however, but let me advise, no sane person goes out of his country to run down his national institution. It doesn't happen anywhere. If you meet Ghanaians, they will keep making you believe that Ghana is the best. I have worked with Ghanaian judges for up to 10 years in different panels. I know the truth. I have worked with judges from East Africa and other places. We remain the best. The reality, however, is that both courts and legal practitioners have some share of blame for the existence of these weaknesses, even though the courts control proceedings before them and determine their outcome. Experience through the cases show that the practices of legal practitioners are in most situations the primary causes of most of these weaknesses, because they start the processes that create each weakness. The weaknesses come into existence and thrive because of the failure of courts to prevent or control the practice of legal practitioners from enabling the existence of their existence. Let me illustrate this with some situations, examples. Let me start with conflicting judgments. Conflicting judgments may not exist if legal practitioners do not raise for determination issues already settled by judicial precedents in previous cases with similar facts and issues, without reference to or in disregard of each such precedent or of legal or such precedent, or if legal practitioners do not litigate or argue contrary to settled case law. This results in judgments that conflict with existing judicial precedent and settled case law. This has also resulted in the Court of Appeal and the Supreme Court rendering judgments that conflict with their previous judgment in cases with the same facts and issues without deliberate and well-considered decisions to depart from the previous ones. But if the courts do not allow themselves to be misled by the arguments of counsel, of legal practitioners, into delivering judgments contrary to judicial precedents or settled case law, or to their previous decisions in cases with the same facts and issues, such conflicting judgments will not occur or exist. In Chief Judo Keke versus Abga and others, decision of Supreme Court in 2021, the Supreme Court adjudged the practice of the legal practitioner filing a suit to litigate the issues already settled by case law as unethical, and the practice of the trial judge in admitting and trying the case as judicial misconduct. The exact text of the statement reads thusly: the law is settled on the issue of which state you should take your case to. You should not take a case that occurred in Aba to Jigawa, that's across territorial jurisdiction, forum shopping, and the law was settled on whether on issue of membership and management of political party. In disregard of this, the settled law in the long line of decisions of this court cited above, the third respondent as plaintiff on 30th June 2021 filed a suit at the High Court of Jigawa State challenging the election of the second respondent as the acting chairman of the first respondent at the convention that was held in Owerri, Imo State, and the validity of the second respondent's primary elections at Oka in Anambra State to select its candidate for the impending general election of Anambra State. Repeated restatements of our law in several precedents from the Apex Court result in the law being so well established that it enjoys definitional precision and is no longer open to question or dispute until there's a change in the law by a clear departure of legislation. The first precedent acquires more respect and permanence as a legal doctrine with its repeated restatements. All authorities, including the courts, and all persons, including legal practitioners, are bound to follow precedents and settle case law by virtue of Section 287, subsection 1 of the Constitution of the Federal Republic of Nigeria, which provides, I have stated it there, the legal practitioner that filed the suit in contravention of certain case law and Section 287, sub 1, engage in unethical practice. The learned trial judge of Jigawa State High Court that admitted and tried such a suit in disregard of the law settled by the decisions of this court and Section 287, subsection 1 of the 1999 Constitution, engaged in judicial misconduct consequent upon the violation of his judicial oath to observe, comply with, and uphold the law. Stare decisis is the foundational and directive principle of our legal system. It obligates the courts, legal practitioners, and other institutions of administration of law to follow judicial precedent in similar cases. This obligation has constitutional foundation in Section 287 of the Constitution. The principle ensures uniform application of law, consistency, certainty, predictability, and fairness, and avoids conflicting judgments with resulting uncertainty of the prevailing law and loss of public confidence in the courts. Uncertainty of the prevailing law results in lack of predictability of legal consequences, which makes it difficult for individuals and organizations to plan their activities according to law. This unpredictability also generates confusion, increased conflicting judgments, differential treatment of similar cases between judges, creates room for increased litigation, abuse of legal processes, and discourage investments and economic activities. The Supreme Court has not remained indifferent to the recurring incidents of conflicting judgment. It has taken several steps and established case law to deal with it. Prominent among its response to this situation is the established case law that conflicting judgments of the Supreme Court shall be resolved by reliance on the later of the judgments as the prevailing judicial precedent. The case law is applicable to conflicting judgments of the Court of Appeal concerning a point on which there is no Supreme Court precedent. In Federal Republic of Nigeria versus Ibrahim Gidado, the Supreme Court laid down this point again, where it had to deal with the issue of whether the Supreme Court has jurisdiction to entertain appeals on grounds of mixed law and facts from decisions of the Court of Appeal. Certain conflicting views had arisen, and the Supreme Court had to rise up to the occasion to resolve those conflicts, and came to the conclusion that by virtue of Section 233, subsection 1 of the Constitution, which vests exclusive jurisdiction in the Supreme Court to hear all appeals from decisions of the Court of Appeal, the Supreme Court has jurisdiction to hear appeals on facts or mixed law and facts. Another example is abuse of court process by multiplicity of suits over the same event that often results in contradicting orders. This has become commonplace in recent times, particularly in election and politics-related cases. A litigant, in a desperate bid to avoid compliance with an ex parte order of court, rushes to the same court in another division or to another court of coordinate status to obtain another order ex parte that contradicts the earlier order. Legal practitioners are the primary cause of this problem. The courts often claim not to be aware of the earlier order and to have been misled by legal practitioners to grant the later order. This practice has caused much damage to the reputation of courts generally and is a major impetus for allegations of judicial corruption. Another example is delayed trial processes and attendant lack of hearing within reasonable time, very stressful and frustrating access to courts and justice. In many cases, the delay in the assignment of cases by chief judges of states extend up to 8 months from the date of commencement. Many cases hang in the courts from the date of commencement for as many as 10 years in the trial high courts, 5 to 10 years in the Court of Appeal, 10 years in the Supreme Court, a total of 15 to 20 years before final determination. In many cases, delay in the delivery of final judgment by judges of superior courts extend up to 2 years and even more from the date of conclusion of evidence and final addresses. Contrary to Section 294 sub 1 of the Constitution of the Federal Republic of Nigeria, which requires that every court that is established under the Constitution shall deliver its judgment, its decision in writing not later than 90 days after the conclusion of evidence and final address. Experience has shown that both legal practitioners and the courts engage in practices that create these delays and frustration of access to justice. The practices of lawyers that cause these problems include deliberate delays in taking steps in the proceedings aimed at stalling and frustrating the expeditious trial of a case, the use of preliminary objections to stall or block the trial of a case, frequent requests for adjournment, piecemeal litigation of issues that can conveniently be taken together in the final address after conclusion of evidence, interlocutory appeals aimed at stalling the progression of trial proceedings, frivolous suits, frivolous technical objections, false and misleading assurances and advice of litigants, dilatoriness, encouraging disobedience of court orders, unethical practices, abuse of court processes, lack of diligence and competence in the conduct of cases, frivolous applications for interim and interlocutory injunctions, frivolous applications for refusal, etc. The practices of courts that cause these problems include going late to work, late commencement of the sitting of court, not sitting on scheduled days, adjournments due to habitual absence of a judicial officer from court, delay in assigning a new case to a judge, delay in listing a new case on the daily course list of the court, delay in starting the hearing of a case that is ripe for hearing, lack of interest in and commitment to the diligent, expeditious, and just delivery of justice, indiscriminate and unreasonable adjournments, indifference to the abuse of legal and court processes, allowing the use of preliminary objections to stall or block the trial of cases, granting requests for adjournment as a matter of course, piecemeal litigation of issues that can conveniently be taken together in the final address after conclusion of evidence, admitting the hearing of interlocutory appeals aimed at stalling the progression of that trial proceeding, allowing frivolous technical objections, condoning the dilatoriness of counsel, granting frivolous applications for interim and interlocutory injunction, granting frivolous applications for recusal, poor knowledge of law, and incompetence of judicial officers, granting applications for extension of time as a matter of course, pervasive acute indifference to the demand of substantial justice in each case. I didn't mention that case here. I had to deal with this matter in the case of Suswan and, is it Federal Republic of Nigeria? And they said, once there's an application for recusal, if the judge is not biased, he should just throw away the file to the chief judge to reassign. That is not correct. That is not correct. A judge will not simply transfer a case for the asking. The law has always been, Oluware Nengwali, 1976, and so many of them, that he should not transfer a case from himself on the basis of whimsical allegations, feelings of bias. There must be reasonable basis for thinking that there is real bias. If that doesn't exist, you don't just transfer a case because a party say, recuse yourself. And there is one lawyer who is very notorious for that in one of the states. He has recused judges in about 7 courts on the same case. Where he's not sure the direction of things from the way things are going, he will apply for recusal. And they keep indulging him. And for 14 years, the case keeps going back. Alhaji Bashir Abubakar Koko versus Alhaji Dan Ige Iro Horo. It's a decision of this court, 2025. The appellant was not able to have his claim tried for 17 years after he commenced his suit in the trial court, and to have access to legal redress due to the obvious lack of interest or competence of his lawyer to prosecute his claim. This court held this case typifies how the lack of diligence of a legal practitioner in the prosecution of a litigant's case holds up or renders illusory access to justice, a determination of rights and obligations within a reasonable time, and destroys public belief in or regard for the courts and legal processes of dispute resolution. It is by efficient, effective, and diligent prosecution of the client's case, pursuing its expeditious determination by a court within a reasonable time, that the lawyer is able to ensure that justice is both available and achievable in keeping with the litigant's expectation in seeking legal redress. A litigant expects that justice is available to be achieved within a reasonable time in a court or legal system. This is the impetus for actions in court and other legal processes. If a legal practitioner's conduct of a case rather defeats that expectation due to inefficiency and lack of due diligence, then he or she has failed in the performance of his professional role of promoting access to justice. There is no access to justice if justice is not available and achievable within a reasonable time. In GP Industries Nigeria Limited and another versus MV Kota Manis, 2025 judgment of the Supreme Court, the court deprecated the judicial approach of allowing the use of preliminary objection to stall or block the trial of cases, and of being indifferent to the abuse of legal and court processes, and restated that the resulting very long delay of the judicial process rendered its outcome sterile. The exact text of that portion of the judgment is here, and where they had to consider a case filed in 2013 and determined in 2025 whether the claim for a certain amount of money in Naira was still, the amount claimed for that time was still of the same value many years after. And the court had to now consider the exchange rate as at then and as at today to discover that it was an empty victory for the plaintiff. The Supreme Court has continued to admonish lower courts to determine preliminary objections along with the merit of the case, to avoid the abusive use of the process of objection to frustrate the trial of the merit of the case. We've reproduced those decisions there. Now, in the case of election matters, it is common to find the respondent doing everything possible to ensure the frustration of the expeditious trial of the plaintiff or the petitioner's case. In PDP versus Senator Henneken Lokpobiri, the Court of Appeal concerning the role of legal practitioners for defendants to pre-election cases in frustrating the expeditious hearing of pre-election cases held, it has not escaped the notice of this court that in the many pre-election appeals that have come before it, the emerging pattern is that the defendants to such suits do not support the expeditious disposal of such cases before the holding of the general elections, in keeping with the tenor of the Electoral Act. All sorts of challenges are mounted as roadblocks by the defendants on the part of the accelerated hearing of such cases, preventing them from moving forward to protract the hearing to the advantage of the person who is the candidate and who in most situations contests and wins the election, gets sworn into office, occupies same and is functioning in the office, while the suit dealing with matters that ought to be settled before the election is pending. Some of the challenges may be well-founded in law and the facts, and therefore bona fide, but most are not, and devised as part of a stratagem to work against the expeditious trial of the case and the effective enforcement of the Electoral Act. Such an approach is not helpful to the cause of justice, due administration of the law, and amounts to obstruction of justice and a gross abuse of the legal process. Legal practitioners and the court are primarily agents of law enforcement. Their first duty should be to the law. The effectiveness of law in the society depends on how the courts and the legal practitioners discharge their public responsibility of law enforcement. So the effectiveness of the Electoral Act and the deepening of the culture of democracy and the rule of law in society depends on how we discharge our responsibility in the enforcement of the Electoral Act in election cases. The sensitive nature of an election matter that makes it preeminent over ordinary civil cases is its importance to the well-being of the society. These are illustrations of our joint contribution, both courts and lawyers, to the problems bedeviling the legal system or weakening the legal system. I started from the premise of saying the lawyers act as if the responsibility of running the legal system is only that of the courts. And therefore, all the problems in that system, they're created. They create the problems. And I've brought out these cases to demonstrate that no, it's a joint responsibility of role performance and problem causing. The next issue is public perception of the courts as corrupt and lacking in integrity. The widely spread and held belief is that Nigerian courts are corrupt and lack integrity. Several Nigerians have spoken in IBA conferences, many local conferences, local and social media, making general assertions condemning the Nigerian courts as corrupt. This has largely encouraged the public perception of the courts as corrupt. Legal practitioners, being ministers in the temple of justice, what they say, however vague, baseless, irrational, and unreasonable about that temple, may be believed or taken seriously by the public. A 2017 report of a survey carried out by the National Bureau of Statistics in collaboration with the United Nations Office on Drugs and Crime ranked the judiciary as second to the Nigerian police force as the most corrupt public institution in Nigeria. The report contained no verifiable basis for the conclusion. The NJC, the MBA, senior advocates of Nigeria, and many other lawyers rejected the report as speculative, subjective, and baseless, as it did not state the method used for the survey and the data or any reason that form the basis for such conclusion. Such a report from highly respected institutions, though speculative and baseless, would have increased the negative perception of the courts in Nigeria as corrupt. Like the Wolof say, Sai has not spoken the truth, but he has spoiled people's minds. Sai is the rascal. As it is, there is very little or scanty evidence-based fact of corruption by judges. So the widely held belief that courts in Nigeria are generally corrupt is based on rumors, unverifiable assumptions, speculations, and deliberate falsehood. Adjudications and judgments in election-related cases are generally suspected and assumed to be corruptly influenced. From experience, the common and routinely regular pattern is that the party that is not favored by the decision resorts to calumniating the judges as having been corruptly influenced by the other party to render that decision. Their legal practitioners routinely hold post-judgment press conferences in the court premises, condemning the court judgments they had not seen nor read as wrong. Many resort to social media and mainstream media, condemning court judgments they have not read in very abusive, condescending, and derogatory terms. A very highly respected senior counsel was quoted to have instigated the lawyers that appeared with him in a politics-related case to go to the press and social media and condemn a judgment that was not favorable to his side. Another very respected senior counsel speaking in the presence of the President of the Federal Republic of Nigeria, members of the Federal Executive Council, some state governors, members of the Diplomatic and Consular Corps, and other very eminent Nigerians condemned the courts generally for poor judgments and even described a particular judgment of the Supreme Court as silly, without stating any reason for describing it so. Some legal practitioners are permanently engaged in the calumniation of the courts and court verdicts. A Nigerian lawyer and a Christian cleric from the United States of America, under the auspices of a civil society, mobilized calumny of global reach against the Supreme Court for its judgment in Sunday Jackson versus the state. 2025 judgment. The duo spoke in several media in Nigeria, alleging that the Supreme Court has committed another injustice by affirming the death sentence of a Christian farmer who defended himself from being killed by a Muslim Fulani headsman that attacked and tried to stab him with a knife in his farm. The narrative portrayed the Supreme Court as supporting Muslim Fulani headsmen against Christian farmers, contrary to law. But 3 of the 5-member panel were Christians. That's the unfortunate part of it. The Supreme Court had, by a majority decision of 4-1, affirmed the concurrent findings of the trial high court and the Court of Appeal that the appellant's evidence failed to establish self-defense and that the defense of provocation could not avail him or be sustained on the same evidence. The Supreme Court held that, whereas in this case, a person successfully wrestles and disarmed the other person that had come to stab him, threw him on the ground, took over the dagger, but did not escape or retreat after seizing the dagger, and used same to stab the now unarmed assailant thrice on the throat, killing him. The stabs on the assailant clearly amount to reprisal or revenge attacks and not acts of self-defense or provocation. This was what the Supreme Court said. They had not read the judgment. They were on the televisions. The white man was there with his white collar. I was watching him. And the lawyer was there beside him, virtually crying that another injustice again. I was in the panel of the court. I'm a Christian. So I didn't even know what was happening. So listening to them, I said, that case sounds familiar. Then I remembered. I was shocked at the whole turnaround and twisting. So any student of law should know that it is elementary law that you cannot rely on the same evidence to raise self-defense. And when it fails, it's okay, try me provocation. It cannot function because the two are mutually exclusive. Self-defense, you admit that you intended the action, but to defend yourself. In provocation, you say you lost self-control, that you didn't even think, you did not intend the action. And the Supreme Court did not just say that. It went ahead to refer to decisions of this court way back, where this point has been made. And if you reach English texts, you find the same position. But since the truth was not important at this time, what was important was a narrative to calumniate the court. The law didn't matter. And the social media platform of lawyers were awash with total condemnation of the Supreme Court for stating the law correctly. The lawyer who spearheaded this attack on the Supreme Court was either ignorant of this settled law or plainly malicious. Another experience is that while election-related cases are pending in court or about to be filed, you hear and read lawyers in the media vaunting that the decisions in those cases would favor their client if the court or tribunal is not influenced. Such unethical and unprofessional behavior set the stage for the court to be accused of being corruptly influenced if the decision favors that party. I had watched that happen. There was during the presidential election petitions, and I saw a particular lawyer who was supposed to be what I can't even remember. And they say, yes, we have got the smoking gun now. If they do not throw him out, then it means they have been corrupted. So when you do that, the court has only one decision to make. Say what you have required them to do. So that's the problem. And the public go with this. And so many other cases. The judiciary on many occasions through the Director of Press and Information of the Supreme Court has reacted to these unwarranted attacks of the judiciary and judicial officers, warning those engaging in those attacks to stop doing so, as it is misrepresenting and blackmailing the judiciary to the public. In one of the statements during the 2022 election litigations, he noted that over 600 cases had so far gone to court from party primaries conducted by political parties without any encumbrance or interference from any external body. The statement added, our silence must not be mistaken for weakness or cowardice. Certainly every Nigerian citizen has an inalienable right to express his or her opinion without any encumbrance. But even the cause of expressing such a fundamental right, we should be circumspect enough to observe the caution gate of self-control in order not to infringe on another person's right. He went on and on. The lawyers reacted to this statement. Senior Advocate of Nigeria, Kunle Adegoke, said, let me quote him, if court judgments must be criticized, it must be from point of view, not just on perception. There's nothing wrong in criticizing court judgments. They are public documents good for public scrutiny. But enlightened criticism demands that criticism is based not only on logic, but also the law, because sometimes a judgment might sound illogical to the public, but might be sound in law. If we expose the judiciary to ridicule, we will erode confidence and introduce anarchy, which will not benefit anyone. The then president of the Nigerian Bar Association, Yakubu Meikiao, speaking in the same year during a valedictory court session held in honor of Justice Ibrahim Buba Meikiao, said, when I read the heart-rending statement by Professor Farouk Berogi over the judgment of the Supreme Court in the case involving Bashir, Mashina, and Ahmed Lawan, I was burning with rage against Berogi, not only to hear like a whisper in my ear, while I sat alone lamenting that you people started it, you senior advocates of Nigeria. He condemned the appearance of lawyers on the television castigating Supreme Court judgments, saying such lawyers would face the consequences of their actions. Dr. Kayode Ajulo, son, now Attorney General, is it Ondo also, expressed support for the NBA president on plans to sanction lawyers criticizing the judiciary over some judgments, adding that if politicians must respect the law, lawyers as custodians of the law must first make it respectable through their actions. Yes, we cannot appeal against the judgment of the Supreme Court, and I maintain that we are of the noble profession, and what is expected of us is to critique the judgment. We all should know that the immeasurable commitment and service of this noble profession is why well-meaning Nigerians still have hope in this challenged country. This is why we must always guide the institution jealously at all times, irrespective of the noise of those who want to influence the profession through emotional means. These general and baseless allegations of obtaining judgments by corrupt influence disregard and disrepute the noble efforts of the judicial officers that are transparent, upright, and fair in the discharge of their judicial duties, and trivialize and disrepute judgments of our courts that have hugely advanced the effective and efficient application of law and promotion of the rule of law, promotion of improved access to justice, have expanded the frontiers of jurisprudence in several areas, improved the electoral jurisprudence of our country, enhanced the progressive application of our Constitution and other laws to promote egalitarianism, democracy, good governance, and anti-corruption, stability and security of society, and promotion of the observance of legal rights and obligations, etc. So many of these judges working very hard, honestly, have made this massive contribution. But you never hear anybody say anything about it. Never. But immediately one decision in a political case is made, the whole legal fraternity will be lit with fire. But when the court sits down soberly in a well-considered manner, lay down for all times a new frontier of law, like expanding the scope of duty of care in negligence by a legislative service provider, you will never hear a whimper from any member of the legal profession. When our brothers sat there and decided that local government allocation shall never get to them, and the Supreme Court, using its interpretative jurisdiction as established across jurisdictions, applied the Constitution to open the gate and emancipate the rural people from the stranglehold of this. I never heard anything. Rather, I heard somebody say he's a professor or something. I respect professors a lot because they are highly learned people, well trained, well read. And he said, the judgment is wrong, and gave no reason. He was speaking on television. That is not an intellectual discussion. So, and they said this, the value of the judgment to society was not even talked about. There are so many like that. Comments on court judgments should be made only after reading the judgments with the motive of making contribution to the advancement of the rule of law and better functioning of the legal system, and not to scandalize or calumniate the judges or blackmail the judiciary. The comments should, in decorous and not abusive language, dispassionately analyze the legal reasoning in the decision, showing how the court applied legal principles to the facts of the case and evaluate the correctness of the decision and the impact on existing law and the society. A lawyer, a senior advocate, commented on our judgment in Imo State Transport Company versus Abia something. And he criticized the court heavily and agreed with the Supreme Court on very substantial parts. And I commended him because that was an intellectual discussion. It was not in bad faith. And he didn't choose a propaganda venue. And he sent me a copy. That is how it should be. If the people who are more equipped to criticize judgments of court are lawyers. If lawyers do not criticize the judgments of court, how will the judges improve in their performance? The criticism is very necessary, but it must be structured in a manner that it will generate the benefit we're talking about. The better and effective, I'm sorry I didn't come with my handkerchief. I have an eye, my eye keeps running. Yeah. The better and effective response to the existence of any form of corruption in the courts is to exploit the well-structured processes provided by the NJC to report to it specific cases with relevant and sufficient proofs of the alleged acts of corruption. This will generate the necessary accountability measures that will deter further acts of corruption. Calumniating judges and instigating the public against them through media propaganda of baseless allegations of corruption creates the bigger problem. Oh, thank you. No, this one will create more problem. This is like calumniating judges. Leave that.
Okay, let's bring it.
Don't worry. Yes, it creates the bigger problem of loss of public confidence, public trust, and confidence in the courts due to a perception, thank you very much, that has gained ground over time and is now appearing like the truth as a result of consistent and persisting repetition of the baseless allegations. In spite of these widespread allegations of judicial corruption, In spite of this widespread allegations of judicial corruption that has persisted over the years, I am not aware of any objection to the NJC against the appointment of any judge for corruption or any other reason during the process of appointment of judges or elevation of judges. Many of these judges had rendered decisions that were widely condemned in the media as corruptly influenced, yet during their elevation to the Court of Appeal and Supreme Court, not a whimper of objection was raised to the elevation of any of them for being corrupt. This is important. The whole place is awash with all that. Many of us believe, but whenever they come to appoint people as judges, we are in this jurisdiction, we know ourselves. So when they call my name, you know me. You know what I have been doing here every day. You all go silent. Then they unleash me on the public. So what do you expect? That's when you now get up to go and do press. There is a structured process where you can help to stem the tide of this problem that you say exists. If you diligently and timeously explore that process, you will be able to stop many people from going forward. If it comes to the Court of Appeal selection, I was looking at one list somewhere. The number one on that list is somebody I know very well. And I was wondering how he can be number one. Yet, the lawyers, none of the lawyers in that jurisdiction who have been petitioning him several times to the chief judge have bothered to raise an objection. If those objections are raised, and some of them are successful, it will become a deterrence to judicial misconduct. But if each time they throw the name up, the objection is not raised, it breeds impunity. The widespread suspicion of judicial officers of corruption, lacking judicial independence, and allegations of corruption against them can also be fueled by their own wrong practices, such as non-compliance with law and rules of procedure in the conduct of proceedings, deciding contrary to law, refusal to follow judicial precedents and settle case law, frequent and long adjournments that frustrate the hearing of the case. Yes, I have come out here to say, look, I'm not saying the allegations are not true or false, but I'm saying nobody has brought any evidence of anything to the appropriate authority to deal with the matter. Now, but why is this going on? Where are these allegations persisting? And I'm saying here, they persist when we continue in our wrong practices as courts. Now, if you engage in some of these wrong practices, they can fuel suspicion about your motive. Why would you make an indiscriminate and phony grant of an ex parte order of injunction? Somebody can suspect. It's natural. If you give a conflicting decision, it can fuel suspicion of manipulation. If you give an order that contradicts with the order of another court of coordinate jurisdiction, the public perception is that something fishy is going on. So the wrong practices are helping to fuel these allegations. So we too have a responsibility to make sure we decide cases in accordance with the procedures of our courts, in the rules, in accordance with law. You cannot see law there and decide contrary to law. When you do that, the first reaction is something is wrong. And many of us, without qualm, do this regularly. It may be in good faith, may be due to ignorance of law, but ignorance of law is no excuse. So you'll be treated as having knowledge of law, but you have decided not to do something unlawful. I don't want to list all the wrong practices so that I don't detain you here again. Those wrong practices, I have listed them. As courts engage in them, even if we refuse to remove the scandalizing propaganda in the press, these very wrong practices themselves will create that suspicion, will fuel an allegation that we are corrupt. And again, we know our judges. You know him as a brilliant judge. You've seen most of his judgments. Then one day, you see him give a judgment contrary to elementary law. You say, hey, what happened here? So these things help to fuel suspicion. The independence of judicial officers equally has two dimensions. The first dimension is external and requires that in making his or her decision, a judicial officer is subject only to the Constitution and other laws and not to the direction of any personal authority. This external independence is often understood to mean independence from interference or control by the executive arm of government, because it is often the most visible form of interference. However, it also includes independence from the interference or control by litigants, legal practitioners, friends, and family members, heads of court, and any other person or authority. The common assumption is that interference and control by litigants and legal practitioners is fast emerging as the most serious threat to a judicial officer's external decisional independence. The other dimension is internal. It requires that a judicial officer must have a settled mindset and personal commitment to contribute to the development of the country and to help humanity through his or her judicial work, and therefore does not see the office purely as an employment opportunity, a means of self-aggrandizement or amassing wealth and self-enrichment. It requires that he or she must not be influenced by the emotions of fear, affection, ill will, and favor in making decisions. It also requires that the judicial officer has excellent knowledge of law, be morally and financially disciplined, to be content to live within his or her legitimate income, to be internally independent, confident, and strong. He or she must be self-contented. Without self-contentment, he or she will lose his or her internal independence and become easily susceptible to external control through other forms of, I don't want to be mentioning them continuously. It must be borne in mind that the basic expectation of the members of the society is that the court should be the bastion of refuge, succor, and protection of persons, particularly the weak and most vulnerable, against arbitrariness, lawlessness, oppression, abuse of power, violation of rights and obligations, lack of access to justice, dehumanization of human person, bad governance, insecurity of lives and property, and destruction of the state. or other form of human community. I've gone on and on. And what the society looks up to the judiciary to do. I will say that the judiciary alone cannot meet these expectations without the legal practitioners properly performing the roles, their roles in the joint responsibility for administration of law and justice and optimal functioning of the legal system. In other words, the judiciary cannot on its own alone meet the expectations of society as I've highlighted here, except with the active support of legal practitioners doing their job correctly. That is the only way out. I have not talked much about applications of the electoral legislations, because that's not the focus of this paper. But I must say that we have a role to ensure that innovations in the Act, Electoral Act, are given effect. The tendency is to see legal practitioners come after 2022 Act to argue that they didn't bring a polling agent as a witness in what happened in a polling unit. The person is saying, look, there was non-compliance and has put forth the document showing so. And 137 is clear, which was an innovation. We have held very seriously as legal practitioners to cause a reversal of that innovation and a movement backwards. Thank you very much. Well, if I did not make sense, bear with me.
Thank you so much, my Lord, Honorable Justice Akomoye, Emmanuel Akomoye, again JSC, for that thought-provoking and highly impactful lecture. My Lord, it's indeed a privilege to drink from your wealth of experience. Thank you so much, my Lord. Can we all resume our seats? Thank you so much. Yes, before I hand over to the chairman for the panel discussion, may I recognize the presence of Honorable Justice Matthew Eluke, Honorable Justice C.C. Ani, the leader of the bar, Honorable Dr. E.E.J. Okereke. You're all welcome. And I will not forget to welcome the presence. I'll recognize the presence of the MBA presidential aspirant or presidential hopeful, and the person of Mrs. Oyikonsola Badejo Okusanya, SAN. You're welcome, ma. Okay, may I hand over to the chairman?
One more time, put hands together for the very illuminating lecture there. It's been a nice one. Yes, you've heard it all. The system, the role of the legal profession and justice delivery in Nigeria. The lecturer has been able to put forth the problems. Who is the problem? Who is the solution? In the book of Luke, chapter 11, verse 46, Christ said, "Woe unto you lawyers, for you put a lot of load on others, but carry none yourselves." In John 8:7, A woman caught in adultery was brought to Christ. She was condemned to stoning. Christ said, "He among you that has no sin, let him cast the first stone." And in Matthew 7:5, Christ said, "Remove the log from your eyes so you can clearly see the speck in the eyes of the judges." That's the Namani version. Yes, the NBA president, Afamosigwe SAN, will talk to us. And by the power vested in me as the chairman of this occasion, it's only 3 minutes. Anything outside it, I will show you I'm a black belter.
Thank you so very much, my Lord. Thank you, my Lord, for coming me to make a few remarks. I would have to excuse myself afterwards to attend another event here. May I adopt the already established protocol and to lend my voice to that of subsequent speakers and every other person would have to commend His Lordship, Honorable Justice Emmanuel Agim, for that thoughtful and very insightful paper presented here this afternoon. I wasn't quite good in jurisprudence, but I somehow fell in love with Roscoe Pound because he felt that law should be used as a tool for social engineering. So that law should be about what use we put the law to, rather than the content of statute books. And I thought that was quite interesting. Though as a practitioner, I think that's why we have a problem in Nigeria. We have become very technical. And I used to remember the words of Oputa JSC, and that too in my legal methods class, and later legal system in second year at the University of Nigeria. And I will quote it because I don't have it offhand again. I used to quote it verbatim offhand. And that was Oputa JSC in Bello and AG Oyo State. Reported in 1986, 5 Nigeria Rookie Law Report Part 45 at page 826. Sorry, somebody keeps calling me. And I'll quote. He said, "The picture of law and its technical rules triumphant and justice prostrate may no doubt have its admirers." He said, "But the spirit of justice does not reside in forms, formalities, nor in technicalities, nor is the triumph of the administration of justice to be found in successfully picking one's way between pitfalls and technicality. Law and its technical rules ought to be a handmaid to justice." And I think if there's a negative perception about the judiciary, it may stem from the undue reliance on technicality. It may stem from people's unmet idea that justice remains unmet, that will become too literal, too technical. And so sometimes I will get worried when an appeal has been made to the Supreme Court and there's a mistake in ground 4, paragraph 4, relief sought from Court of Appeal, and appeal is dismissed at the Supreme Court on that ground. You go away asking yourself, how do you explain to a person that he or she couldn't get justice at the Supreme Court because of a technical slip? And we hammer on them, and lawyers feed fast on these things. I agree that some of us lawyers use uncut language in describing judgments we have not read. I agree that sometimes we go to preempt judgments by being paid to advocate on social media and even on TV. But there's a whole lot that we can do. And your Lordship, this may not be a very good platform, but sometimes you utilize the platform available. On behalf of the bar, we are worried that as of today, if the Legal Practitioner Disciplinary Committee makes a finding against you, you're in a limbo. There's no place to go to. The current position of the Supreme Court is that you should go to Appeals Committee of the Body of Benchers. Earlier in 2018 or 19, the Supreme Court had found that the current state of the law, as requested by Mohammed Bello Adoke as Attorney General of the Federation, is that the law is the Legal Practitioners Amended Act 1994, which has made an appeal direct to the Supreme Court. I know that there's that argument whether the National Assembly can make a law vesting appeals straight to the Supreme Court. There are those that argue that this can be filed. Is this section 283? So, but that point has not been decided. But as of today, once a finding is made against you, you are in limbo. And again, the Supreme Court adopted a current position in 2024 without overruling its decision in Walotu, an MBA rendered in 2018. And I'm being careful with what I say these days. A few weeks ago, I was here in Enugu to give a keynote address. And when I left, I saw newspaper headlines screaming that I said that the judges and lawyers are the most corrupt. I never said that. And for fear of being accused of having said that again, I would like to also say that judiciary is not the most corrupt, but the feeling is that it's corrupt. And my legal knowledge never leaves me that when it comes to the issue of justice, perception is much more important than reality. And that is why I agree with, and I'll read him, well, quote him in extensio, the then Chief Justice of Nigeria, now late Honorable Justice Dahiru Mustafa, when he admitted that it appears that the society is not entirely satisfied with the performance of the society, of the judiciary. And he stated that this was in 2011, he said this, I'll quote him. He said, hard as it may be to accept, we feel it is less important to focus on whether the assessment is fair or not. Continuing, he said, the important thing is for us to transparently come to terms with the prevailing realities, accept the gap in expectations, and do our utmost to bridge it. The Supreme Court is doing a fantastic job. It is the most overworked Supreme Court in the whole world. And there are bound to be conflicts. And I agree that sometimes we lawyers mislead the court. Sometimes we file cases that have no business in court. I know I have 3 minutes, I'm rounding off. The point we are making is that also some of the rules, like amendment of the LPPC guidelines, that focuses on quantity of cases to become SN. Nobody cares whether you were abused all the way. There's a whole lot we can do. The judicial attitude that does not impose cost on a losing party, because we must also reduce the number of appeals. And I say that this question, in answering this question, the role of the legal profession in Nigeria, and justice delivery in Nigeria, I will leave us with this quote and I'll go and sit down, so that the chairman, my lord, the president of the Enugu State Customary Court of Appeal, will not have to time me out. Cassandra Clare, in City of Glass, when he said, in the end, that was the choice you made, and it doesn't matter how hard it was to make it. It matters not that you did. We are a product of the choices we make, and we must make a commitment to ensure that the legal profession regains its primary role, improves public perception of what we do, and make justice delivery not only something that is written in judgment, but something that changes lives and makes a better society and makes the words of our statutes to have greater meaning. Thank you so very much.
Please, we have in our midst His Excellency Governor Peter Ndubisimba, represented by the Honorable, by the cerebral, intellectually intimidating, yet unassuming Attorney General and Commissioner for Justice, Osinachi Najeze. His time will come to talk to us. For now, we're going into the discussions. Because I sat close to Anthony and the SAN, I had a preview of a paper he is holding, meaning his discussion. 27-page paper, typed in 12 font size. So if we change it to 14 font size, it will be like 40 pages. I will call upon him to set the board rolling, and strictly in 3 minutes. How you do it is up to you. 3 minutes. Thank you.
I want to enjoy some privilege. My Lord, my brother, President of Nigerian Bank, has talked of this thing about appeal to the Supreme Court from decisions of the LPDC. The CJN is very concerned and is putting it back on the front burner to be everything to be considered, all the decisions to be reviewed, so that we'll come with the final position.
Yes, let us take 3 minutes.
My Lord,
your time starts running.
Yes, my Lord. My Lord, the Chairman and President of the Customary Court of Appeal, I would like to adopt the protocol which you established. And let me tell people here the secret, while I will not go into protocol. Not because of the 3 minutes you gave to me, but because even if I try to establish any protocol, I may make mistake, and they will remember my mistakes. But if you made any mistake, nobody will remember it, because it was some time ago. My friend and brother, Akaraiwe, I want to thank God for you. I have known this young man for about 47 years now. 47 years. I'm not suggesting that we are old, because we are still very young. And then I thank God for what you are doing in Enugu State, because Enugu State has given you so much. From University of Nigeria, Enugu campus, your wife, your children, all of them in Enugu. Your wife has about the best eye clinic in Enugu. Your stay with Akbambo, Saklem Akbambo, first vice president, NBA from Enugu, chairman, NBA from Enugu. And I think you are trying to give back. When I grow up, you are trying to give back. When I grow up, that is not to say that you are older than me. When I grow up, I would like to be like you. Mr. Chairman, I thought I gave you a secret. You revealed the secret. I don't know what to say. My Lord, the lead speaker, my noble Lord, Justice Agim, I will do what you people usually do at the Apex Court and say that I've had the privilege of reading your paper, not in draft. I read the paper, and I want to say that I agree entirely with all you said. But in our Igbo adage, they have this saying that if you follow somebody to a meeting and if you have nothing to say, you will just tell the audience, my colleague has said all I wanted to say. Please allow me to sit down. My Lord, I will not say that, my Lord. I want to say that I like how your Lordship concluded that this responsibility about rule of law, justice is not just that of the judges. Because when we refer to the judges, is it part of the warning? When we refer to the judges, we also refer to the lawyers. After all, one small boy was asked, who is a judge? And he said, a judge is a lawyer who sits on the bench after standing for a long time at the bar. So it's all of us. All of us are culpable. So, but I say that ours is a noble profession. That's what they call us. That's why the society expects so much from us as lawyers. When we are talking about our duty as lawyers to God, to the society, because to whom much is given, much is required. And I'll just cite one case. and go to the recommendation and conclusion and sit down. I'll finish that in 2 or 3 minutes. I refer you to a case which is not on the paper. The paper will be, I'll give one copy to Ike. The soft copy, I'm sure you'll get it in the email. The Supreme Court said in the case of Human Engineering against UWS Limited, is 2025, part 1987. The court has refrained from commenting on the unprofessional conduct of the lawyers that assisted the applicant in the disgraceful abuse of the process of court. Suffice it to say that lawyers, as operators of the administration of justice system, owe a duty to the society that nurtured them and made them what they are, to ensure that they conduct their activities in a manner that edifies and brings honor, respect, and belief to the justice system. It's a long quotation, I won't go into that. That's what the society, that's what is expected of us. Now, the Lord in the lead paper, gave us the definition of law, but I go to the practical aspect. In jurisprudence, you have so many schools of thought of what the law is. But this one is the one that appeals to me most. That it means the prophecies of what the courts will do in fact are nothing more pretentious. Because if the law is there in the statute books, the common man and the public will not know until they hear pronouncements from the courts. It is in that context that we need to examine the role of both judges and lawyers in the administration of justice. Now, my Lord mentioned conflicting decisions, problems we are having about contradictory orders, and so on and so forth. The most worrisome and the most current is the one that has to do with the PDP. Many of us will recall the order, I think from the Oyo State High Court, mandating the PDP to organize their convention in Ibadan. I think in the same Ibadan, I've listed the cases. Federal High Court said, don't go for that convention. From there, they went to, I think Abuja, another order, do this, don't do this, don't do that. It has become common. It didn't start today. I recall in 1993, during the June 12th problem, there were so many decisions. One, an order of injunction to restrain the then INEC chairman. It wasn't INEC then, Humphrey Nwosu. Restraining him from further announcing the result. Another one, go ahead and announce the result. Many of you here recall that that was one of the reasons the military used to annul that June 12th election. I remember very well in Enugu here, the then Chief Judge of Enugu State is Ozobu of blessed memory, had to direct the registrar, assistant chief registrar, not to receive any process relating to the June 12th election, whether to release or not to release that election. Because lawyers were moving from one jurisdiction to the other, forum shopping, trying to get favorable court orders. The Jigawa case which your lordship referred to, yours sincerely was retained to appear for one of the parties at the Court of Appeal level, then sitting in Oka. As soon as I read the whole processes, I came to court before the justices of the Supreme Court, Court of Appeal sitting in Oka. In fact, the presiding justice now at the Supreme Court was lamenting and lambasting and condemning the lawyers, insulting and abusing almost all the lawyers that appeared. The danger we put the justices into, because many of them had to travel from long distances, because it was a special panel, despite this insecurity at the time, to sit at that panel. After going through the processes, I applied to the learned justices of the Court of Appeal to withdraw the processes. Don't ask me what happened, because after I withdrew those processes, my client debriefed me, and the matter now started its journey, round, until it eventually got to Supreme Court. The point I'm trying to make is that part of the problem we have Yes, all of us collectively, both the bench and the bar. But somehow, because we are referred to generally, after all, somebody said, who are the lawyers? What do you mean by a lawyer? Somebody described it as a society of men bred from their youth to prove by words multiplied for the purpose that black is white and white is black according as you are paid. So they have now given us the responsibility to acquit ourselves. As far as society is concerned, we are guilty without being given a fair hearing. That is why the onus, the responsibility upon us is so onerous that we must be seen, not just live above board, we must live above board. For God's sake, you must not take all the cases. And let me tell you the secret. The moment clients get to know that you look at the merit of the case given to you by a client and take a decision that you will not take it because the nature of the case or the client doesn't have a case, you have gained one client. You think you are losing a client, you have gained more clients. Because that client whom you advise that he has no case will become your campaigner, your apostle, your disciple. Going around, if you have a case, go to Kafo. He will tell you whether or not you have a case. Whatever he tells you, just go with it. That is justice. So all of us are fully involved in the administration of justice. And remember that, by the way, what is justice? We have made it so elusive. I have one small book called Laughter at Law, where the Lord Justice entered a cab and said, take me to the Court of Justice of England. And the cabman said, did you say the Court of Justice? He said, yes, the Court of Justice. He said, don't you know the Court of Justice? You're the only cabman in London that doesn't have the Court of Justice. The cabman said, I thought you said the Court of Justice. For the cabman, that it is the court, not the court of justice. That is how elusive the concept of justice is to the common man. It is our responsibility to redeem this. Let me make a recommendation and sit down, because the chairman of the occasion threatened the president of the NBA about his black belt. I've looked at him, he's taller than me. I don't want to endanger my life. I don't want to take any risk. Let me go to the conclusion, the recommendation which I made. It is insufficient to merely recommend or advocate for the establishment of institutional mechanism or procedural frameworks designed to enhance the efficiency of the legal profession and justice delivery. You can make, no matter how many laws or rules of procedure you make, that is not enough. The statutes are there, the rules are there. But what am I recommending? There's this thing which even the atheists call conscience. That conscience for Christians is the Holy Spirit. For the Catholics in their catechism, they call it Mama. At every point in time, be you a judge, a lawyer, something will tell you that this one you're doing is wrong. Listen to that conscience, whether you're an atheist, a Christian, a Muslim. It speaks regularly to us. The problem we have is that if the thing is always consistent, when you stop listening, that conscience will stop speaking to you. That's why sometimes we say, this man has no conscience, because his conscience at that point in time is dead. But Lord, when I came in here, I saw one young man. So what I'm recommending is rigorous self-examination and reflection for the lawyers, for the judges. Yes, don't write petitions. Don't condemn the lawyers. Don't condemn the judges or the justices. Please, if you have sufficient reason and grounds, my Lord said it here, to complain against a judge, go ahead and do it. I did it. I complained to the CJN, and that judge was queried, and I was vindicated because eventually that judge was sacked, not because of my own petition, because so many other petitions that came against that judge. I won't mention the name of the judge because the judge is not here to defend himself. Now, Your Lordship, I saw one young man here, Johnny Agim, SAN, and I was asking him, is it Joe Agim or Johnny Agim? He said, it's Johnny Agim. I said, my Lord, it was a family business where I was not invited. And I saw the paper which Your Lordship, the lead speaker, my noble Lord Agim JSC, you titled that paper, Institutionalization of Mentorship in the Legal Profession, a Strategic Blueprint for Professional Development. My Lord, I will quote what you said. Johnny, next time, I told him, young man like you, much younger than myself in age, is doing what they call foundation. I'm learning a lot, I'm growing, just like I'm growing to meet Ike. My Lord, I will quote just a few things which you said there, my Lord. My Lord, you said in that your paper, I have a conscience. My Lord, I'm quoting you. I have a conscience, otherwise I should not be going to Holy Trinity Parish. That's your church, my Lord. Or even praying if I don't have a conscience. God is my protection, my fortress, and my refuge. You cannot be evil and expect God to be all of that to you. But whenever I say this, a friend of mine will say, I thought they said you, that is the justices, all belong to courts. It is not so. We are ordinary human beings. Lord, that is your quote. I had difficulty in convincing my in-laws 33 years ago to allow my wife marry me because they claim that all lawyers are members of one secret court or the other. Conclusion. Lord, this is what you concluded before I conclude. Poor leadership and poor knowledge of law. That's our problem today. Some lawyers hold judgments in their hands, but don't read them. They go on television to spew ignorance so loudly and with audacity. It is a shame. I'm quoting my Lord Agim JSC. It is not just these lawyers. I don't know, the greatest of all the culprits are the clergymen, members of the clerical order. They take advantage of the pulpit. The moment they get up to that place, they will begin to condemn all the lawyers. Remember, my learned friends, when they are condemning the judges, they are condemning also the lawyers. Why? During the election petition tribunal in 2023, during the presidential election petition tribunal, I saw big poster in Abuja. These are the men you should watch. Watch these men. Watch these men. You know the lesson I learned from there? Even when your name does not appear in that poster, they are watching you. And remember, the society is watching us. Let me conclude. The legal profession comprising the bar and the bench, governed by statutory enactments and regulatory frameworks in the exercise of its professional duties, thereby serving as a cornerstone of the administration of justice in Nigeria. Notwithstanding this, the efficacy of the justice delivery in Nigeria is frequently undermined by conduct attributable to both legal practitioners and judicial officers. A singular and the imperative recommendation is the undertaking of rigorous self-scrutiny and introspection evaluation by both the bar and the bench. And I conclude before my words. The last sentence. When such a scenario manifests, the legal profession may experience a profound institutional decay, thereby jeopardizing the administration of justice and imperiling the rule of law in Nigeria. I've been asked to stop, and I stop.
He took 22 minutes. Now, should yes, so you heard him. If the bar and the bench are in the dock being tried for all the yields, the bar is the first accused. As Tony Annie. So we'll now call on the next person, Gerald Ezuko, SAN. Three sincere minutes.
I will stick to 3 minutes. What most of us are hearing today, this is not the first time we've heard about issues of legal profession and administration of justice. I won't start rehearsing what had earlier been spoken, but I will add my few contributions. One, Honorable Justice Agim here, my Lord, talked extensively about certainty of outcome. Certainty of outcome in legal proceedings. This is what we know as legal precedent. And once that is gone, once you cannot predict the outcome of what you are about to do in court or what you are doing in court, that is the end of the profession. And once you can get that predicted, you can no longer talk about justice delivery. Because if, based on precedent, that 1 + 1 will give us 2, and you come to court, and you're beginning to find out that 1 + 1 will now give you 12, then we might as well all go home. Now, in this area under consideration, one of the discussants talked about joint responsibility. I agree. First of all, lawyers are the gatekeepers. We allow things to happen in court. If we leave the gates open, then once we leave the gates open, then you can't complain about judicial conduct. When we know that a matter had been decided by the Supreme Court times and times again, why should we in good conscience, bring the same matter trying to manipulate the system? So the blame is not entirely, of course, on judges, but is on joint responsibility. Lawyers have their shares, judges have their shares. My learned brother Tony Ani talked about conscience. Conscience is that internal regulator. Conscience will tell you what you are about to do, the advice you are about to give, whether it is correct or not. And that conscience, as my learned brother said, is that, well, he explained that spiritually, is that the voice of Holy Spirit. But besides Holy Spirit, once you read an authority, a precedent, then you will be able to tell your client that based on the precedent, you should not bring this suit. You should not file this application. Again, I will go further to suggest that in managing the behavior of lawyers or in regulating the behavior of lawyers, I will suggest that cost should be applied. I'll give you an example. Honorable Justice Jabalomon Wambebu, who was the then Chief Judge of Anambra State, in 2008, when I was a regular counsel appearing before her court, she will always tell you that once a matter is called up, once it's for hearing, I will take multiple dates. And I will, on my own, because I believe in the cause of my client's case, on my own, I will inform the court that any day I ask for adjournment, award 500,000 naira cost on me. And Honorable Justice Onwamebu will turn to the other lawyer and said, "You've heard what the counsel has said. well, what is your take on it? Then generally the lawyer will start mumbling. Maybe he can afford it. No. Honorable Justice Ijabelmo will immediately say, well, the same cost applies to all the counsel. Because if you believe in the cause of your client, you will want the matter to be expeditiously disposed of. So I think that, for instance, in Enugu Judicial Division, Enugu is known. Fortunately, I have the privilege of practicing in several jurisdictions. But in Enugu, once you file a suit, the next thing you get is notice of preliminary objection on matters that has been decided 1,000 times. The first thing, once you sue Enugu state government, the first thing you get is notice of preliminary objection that no pre-action notice was served, that the court lacked jurisdiction, that no pre-action notice. You know, these things have been decided. We know that in contractual cases it does not apply. We know that in constitutional cases it does not apply. But lawyers frequently file it. And I will turn around to address the bench this time that where these matters have been settled, you will tell the lawyer that, oh, in exercise of right of fair hearing, you can file the preliminary objection. But once I dismiss it, you pay 500,000 naira cost. So I believe on my own that costs should be used, sparingly to moderate behavior. Thank you so much.
Thank you very much for keeping to time. Thank you. Thank you. Yes, next we call upon Mrs. Joy Obianuju Nani to take the stage. All right, for 3 honest minutes.
My Lord, the chairman of this occasion, the honorable justices here present, may I humbly stand on the existing protocol, sir. Okay. Now, when you look at the theme of this lecture, one thing comes to mind. As a legal practitioner, what is my role? And that role is to ensure that justice is delivered. Now, the learned Sikh raised the question, what is justice? And I don't think he answered that question. Justice simply means doing what is fair and right for everyone, ensuring that justice is not tilted for the rich and the privileged, that those that do wrong are held accountable, and those that are treated badly are protected under the law. That is justice. Now, when you look at the legal profession, you can't talk about the legal profession without talking about the lawyers and the judges. The learned Sikh also emphasized that those that sit on the bench as judges were once lawyers standing at the bar. So I'm going to take it as a holistic institution. So when you talk about the legal profession, you're talking about the lawyers. Even though we know we're talking about the lawyers and the judges. Now, there cannot be a legal profession functioning effectively without considering the welfare of lawyers. Most of the time, immediately you see a lawyer, the first thing that comes to mind is power, eloquence, prestige, dignity. We have a lot of powers. I've done cases for people that are almost twice my age, and when you finish, they say, from today, I'll call you my mother. Because it's only my mother that can do what I cannot do. And what you have done today, I cannot do it. So as a lawyer, we possess a lot of power. But we know that beyond that polished nature is a different reality. We have lawyers who are overworked, underpaid, people that are emotionally strained due to long hours of work. So we need to consider the welfare of lawyers. In every institution, when the lawyers go to the police station, go to the EFCC, I don't think the way they are treated is the best. So we need to have a stakeholders interaction with all these institutions to ensure fair treatment, not just for the citizens now, but also for the lawyers. Now, when the lawyers are comfortable, then you talk about their roles in justice delivery. And one of the major things you have to consider is advocacy. The lawyers are the people that the citizens run to when they encounter conflicts. They run to them for advice, and in turn, the lawyers go to the judges for them to interpret the law in respect of the conflict. So that is one of the major roles of lawyers in justice delivery. Also, the second role is promotion of the rule of law. When you talk about the rule of law, the legal profession is expected to hold the government accountable for the things they do. They are expected to ensure that the law applies equally to everyone. That is our major role. And thirdly, we have the role to promote and ensure that we have legal reforms. We cannot continue on the same style and on the same pace all the time. We need to embrace technology. A lot of us are kicking against virtual court proceedings and electronic case management, but these reforms are necessary in justice delivery. So we need to ensure that we embrace legal reforms to ensure that justice is not delayed. When justice is delayed, investors are not in a hurry to go to a jurisdiction where they know that they will not get justice for years. So it is very important that as legal practitioners we embrace legal reforms. And finally, it is our role to protect the rights of citizens. That is one of our major roles. Ensure that the law always addresses the right of the citizens, not the law to use as a tool to deprive the poor of what they have earned or what they believe. So at all times, we must ensure that the legal system in Nigeria is strengthened towards the welfare of lawyers and for every citizen to maintain their rights and ensure that we have a healthier and a safer society. Thank you.
Thank you very much. And that brings the discussions to an end. Please put your hands together for all the discussants. They've done so well. And we come to another segment of the intellectual meet. Comments from distinguished contributors. Comments, 1 minute for each person commenting. We'll start with Learner Sikh Badejo Okusanya SAN. 1 minute.
I will not be discouraged by the fact that you didn't clap for me. My Lord Honorable Justice Agumaye Emmanuel Agim, all other protocols observed because of the eminent personalities that are sitting on this side of the room, and if I attempted to name them one after the other, I'm sure, to mix the order up. Distinguished colleagues, my contribution or comment will be a little disruptive because I think, my lords, I do apologize. Good morning, my lords. Because we've been hearing about these problems for as long as we've all been called to the bar. The role of the legal profession, the problems with justice delivery. The question I ask is, who will bail the cat? The problem is there. Who bails the cat? And unfortunately, I'm unable to accept that it's a joint responsibility, at least not now. I think that the responsibility to fix the system lies primarily with the judiciary. Because it is in court that we realize, if we didn't know outside, that we have seniors, and that senior is the court. Lawyers go into court and we are subject to what happens in court. And therefore, it behoves the court to determine the direction in which the rest of the profession will follow. Thank you very much. In 2014, a man called Admiral H. William McRaven delivered a commencement speech at the University of Texas. That speech has come to be known as Make Your Bed speech. The Make Your Bed speech. And it went viral, about 60 million views by 2022. And the first lesson that he proposed for graduates of the University of Texas, in order to fulfill the mantra of the University of Texas, which is, what starts here can change the world. And he proposed 10 lessons for them to try to change the world. The first one was that you must make your bed every morning. And that for him, as a Navy SEAL, when he was undergoing the training to become a Navy SEAL, having to go climb mountains and go through ice cold water at midnight and all sorts of other physically tasking roles, it seemed a bit incongruous that they would be asked every morning to make their beds and that those beds would be inspected. But what it taught them all is that little things matter and that little things lead to big things. And so, I think every court should sit at 9. Sit at 9. Sit at 9. Come hell or high water, sit at 9. No official assignments. The court is a judge's official assignment. If we have to represent the chief judge at any seminar, let it be one that happens from 2 p.m. Sorry, Mr. Ikeazo Akaraiwe. Next year, start this event at 2 p.m. so that if you're going to invite any of their lordships, they can sit before they come here. Why? Because little things matter. When every court sits at 9, every lawyer knows that they must be in court at 8:45. And we will not solve one problem by creating another. In Lagos, for instance, there's no money for diesel. So the generator doesn't come on until 10. But some courts still sit earlier than that. And they get what they can get done before the generator comes on. After some time, the administration of justice system knows that they have to fix the problem that's causing the generator not to come on time, because the court must sit at 9. If the court for any reason will not sit, I don't have to travel to Oka to find that out. I don't have to leave Enugu, travel to Oka before I find out that the court is not going to sit. Because, first of all, it happens in very rare circumstances and I will be informed in advance. And why does all this matter? Because little things matter. Because some litigant whose case is now adjourned for the next 6 weeks, has suffered a setback, because we all know that justice delayed is justice denied. And when those kinds of things begin to happen, when we all recognize that the courtroom is a bastion of discipline, believe you me, we will all fall in line. The truth is, many judges, and I did say I was going to be disruptive, not all of them, and unfortunately my heart bleeds for those judicial officers that take their charge very seriously, but many judges unfortunately do not appreciate the role, the extremely important role that they have in society, not just to the profession. I consulted my good friend ChatGPT and just asked a question, just give me a definition of a judge, and pay attention to the profundity of the role that a judge occupies in society. And this is what my good friend said. He said they are arbiters of truth. They are the protector of the vulnerable, the architect of social stability. These are very heavy responsibilities. Moral conscience, the keeper of the social contract. Now, I want to ask, with due respect, how many people seeking for appointments as judicial officers actually stop to think, am I going to be able to discharge this heavy burden? Because that is what the things that my Lord Justice Agim was referring to in his paper, is the problem that many judicial officers do not yet appreciate, that makes them almost slavishly pay obeisance to technical justice, granting lawyers indulgences that they shouldn't have. So I want to round up. I know I've been disruptive, but sometimes I think we reach watersheds where we really have to think about this thing. To reiterate, I don't think the responsibility is joint, not now. The responsibility is to the judges. Make the courtroom a bastion of discipline. Everything and everyone will fall in line. Recognize and appreciate the role that you have. Exercise your judicial power with extreme discretion. I know enough has been said about this, but with due respect, there is no place whatsoever for a judicial officer to tell a lawyer to kneel down. None whatsoever. And therefore, when a judge who has the moral and intellectual standing conducts his or her courtroom with the kind of discipline that the profession demands, everyone else will fall in line, because even lawyers will call colleagues to order when they are not falling in line. And so, sir, Mr. Chairman, I think enough about the problems, and let's practicalize. One practical, I must give this practical solution. Who says that a chief judge of a state, for instance, cannot invite all the chairmen of the MBA branches in that state and sit and say, look, we are going to adopt a policy in this court. Courts will sit at 9. We will not grant frivolous adjournments. If we do, we will award what we constitute punitive costs. You go back to your branch meetings and tell your members, this stops now. Let's try it first. Thank you very much.
Thank you. Thank you, particularly for keeping to 3 minutes. Yes, next is the chairman, NBA Enugu branch, VC Odo, for 1 minute.
My lords, I want to first thank the noble Lord, the lecturer, for being so exhaustive, covering the field and leaving virtually nothing. My Lord, I'm most grateful for the education you have given us this morning. I want to please reflect on a few things regarding enhancing justice delivery. The number one, which many people have thought about, is strengthening our institutions. In this regard, when you look at the judiciary, my Lord talked about bipartite responsibility between the bench and the bar, but his voice apparently was heavier in describing the failings of the lawyers. But I want to say, my Lord, that even the bench need to also get strengthened. We remember that there was a time in Nigeria some years back when the executive felt it has got to their nerves, and there was what was called sting operation. We did not applaud it, but it happened, and the outcome was not happy at the media space, and it was not lawyers that did all of that. So I want my Lord to take note. We should also try to embrace technology like my colleague said. But in this regard, I would like to think that, for instance, at the Supreme Court, to avoid conflicting judgments, if it's possible, to electronically compare judgments and ratios to ensure that before a judgment is delivered, previous decisions on that topic, on the matter, on the subject, had been compared. And when you are giving a decision, you are certain that it's not going to conflict with any previous one. The third one is that we need to promote alternative dispute resolution. My Lord, in this regard, I am thinking, I raised it here during one of the law weeks. Why is it that regardless of the notoriety of judgments emanating from election petitions, from tribunals up to the Supreme Court, we have not considered alternative dispute resolution in election petition matters or in electoral matters? I think that we have come to that time. Let us look at it and see whether we will have a better outcome. Then, of course, can we also do something to enhance legal aid as a way of enhancing justice delivery in our system? People have various challenges. They suffer injustice, but they have no access to the courts. Something can be done to help them. Some people are doing their best, but their best may not be good enough for the moment. Before I exit, my Lord, because maybe my time is up, but I want to thank Akaraiwe SAN for always giving us this intellectual banquet every year. And he has been a pace-setter for legal education in our branch. And incidentally, he's also the chairman of our branch Continuing Legal Education Committee. So, Mr. Akaraiwe, and we thank you so much for this, your contributions, and we want to encourage you to continue to do so for the benefit of our members. Thank you so much.
Thank you very much for keeping the time. Next is Gozie Obi SAN. 1 minute.
Good afternoon, everybody. Almost all the angles have been covered. I will not repeat areas that have been discussed upon. Having said that, I would like to zero in on two specific areas. My Lord, Honorable Justice, again, the eminent lecturer, in his lecture, dwelt peripherally on appointment to the bench. And he seemed to have limited the role of the bar to writing petitions upon or after there is after there are nominations of selected applicants for judicial position. I feel that that should not be just the role of the bar, that of writing petition. I feel the bar should play a more active role in the appointment of judges. Many schools of thought believe that the problem we have today in our justice delivery system is because the bench is constituted by a few persons who ought not to be there. So if the appointing system is made in such a position, in such a way that you throw up proper appointees, that will be better. In this respect, I will want to observe that the institutions that play a role in the appointment of judges at the national level is the Federal Judicial Service Commission, while at the state level we have the Judicial Service Commission. Now you find that in these institutions, the number of lawyers who are members of them are very few and often do not have a say in what goes on. So I am advocating that instead of limiting lawyers to that of writing petitions after shortlisting of appropriate candidates, that lawyers should be in these bodies that decide on who to be shortlisted. Now the second point I will want to make is with respect to the constraints in the justice delivery system. Now the eminent jurist limited a number of constraints, but there is one prominent one that he appeared not to have mentioned, and that is the issue of funding and financial autonomy of the judiciary. That is a serious impediment to the administration of justice. I remember, I think it was 2 or 3 years ago, that the president issued an executive order that would have made financial autonomy of the judiciary possible. But the Supreme Court themselves shut down that executive order as being unconstitutional. So I will plead that more advocacy be made to ensure financial independence of the judiciary. That will help in resolving most of the constraints we have in the administration of justice. Now, finally, another serious impediment was glossed over, and that is the interference of the executive in the appointment of members of the bench. At the state level, we have undue interference and influence by the executive governors, while at the national level, the presidency. More advocacy should be made, particularly if need be, to amend the laws to remove entirely the executive in the process of appointment of members of the bench. Having said this, we all know that effective administration of justice system is indispensable for the upholding of the rule of law. I therefore enjoin all of us to play any role we can to ensure that we have a veritable and efficient administration of justice system. Thank you very much.
Thank you very much. Next is Johnny Agim, SAN, for 60 seconds.